House of Commons Standing Committee on Access to Information, Privacy and Ethics. I'd like to remind members that today's meeting is televised and will be made available on the House of Commons website. Today we are studying the main estimates of 2021-22, Vote 1 under the Office of the Conflict of Interest and Ethics Commissioner. Following the Commissioner's appearance, all members, if members do agree, will be voting on the estimates and discussing some committee business as well. Just a reminder to committee members that next week we have set aside for the consideration of the draft report on the study of the questions of conflict of interest and lobbying in relation to pandemic spending. But this afternoon, first up, we do have the Commissioner for the Conflict of Interest and Ethics post, Mr. Marion Dion. Thanks so much for joining us. I know that you've been a very busy Commissioner, and we appreciate that you've made the time available to us in our study of the estimates. Mr. Dion, the floor is yours.
Merci beaucoup, Monsieur le Président, et merci.
Thank you very much, Mr. Chairman. Thank you to the members for having invited me to your committee in the context of your study of the office's submission for the 2021-22 main estimates. As many of you were not involved in the committee until last year, I will quickly describe the goals of my office since its creation 14 years ago. Our primary goal is to help regulatees, that is public office holders and members of the House of Commons, know and follow the rules in the Conflict of Interest Act and the Conflict of Interest Code for members of the House of Commons. In order to help the individuals subject to the rules, we continually improve how we communicate and engage with regulatees. This not only supports our primary goal, but also helps build trust in the office and in turn shapes the expectations of Canadians. It is important that our continuous dialogue take place to avoid breaches as much as possible. There must be trust between elected and appointed officials and their advisors in the office based on mutual respect and professionalism and cooperation. Over the years, a solid information management system has been created, and it is the key to the provision of consistent advice. It allows us to improve our efficiency because we don't have to reinvent the wheel every time advice is sought. Our already established, and we provide consistent advice. Our already established movement toward a digital office helped us tremendously when we moved to a virtual office in spring 2020 due to the pandemic. The process was nearly seamless for us.
With a total of 51 indeterminate positions, most of the office's resources are dedicated to our primary goal, helping regulatees meet their obligations under the Act and the Code. These resources are not just in our advisory and compliance division, although this is where almost 1/3 of our employees work, including your advisors, but it's also located within the communications group that provides educational documents and develops presentations for regulatees. We also have a legal services and investigations division, which offers the legal opinions we rely on and, of course, conducts investigations. Finally, our corporate management division handles blind trust, and in addition, of course, to providing us with all the HR, information technology, and financial support that we need. In the past 2 years, and I use 2 years because I haven't been before this committee since May of 2019, the number of reporting public office holders has increased by 7%. And the office helps them, as well as the MPs, as well as the other public office holders. We have a total group of about 3,200 people that we serve. And we mostly, vast majority of situations, we help them through email and telephone. And it was the case already before the pandemic. So that's why it was relatively easy for us to switch to a mode when the pandemic hit. Requests for presentations have dropped, obviously, because, of course, the pandemic has caused people to focus on their real delivery priorities. So we've had less presentations given in the last fiscal year. But requests for advice, however, were up through the pandemic, particularly in the last 2 quarters. So in our So we have revived already the presentations, and I've placed the focus recently on very specific high interest subject matters, such as recusals, such as outside activities, post-employment, that appear to reflect the most concerns for regulatees. So I had a session on recusals a few months ago, which was very well attended by over 300. On June 8 and 16, I have invited already all the reporting holders to a session on offers of outside employment and post-employment obligations. Requests from the public for information have also increased 27% over the last fiscal year. There has been a steady interest from the media in the work of our office. Given the restrictions placed upon me by the Act, we've worked hard to ensure that we are as open and transparent as possible with both the public and the media. Our approach has included more active use of Twitter to share information and updates. So we have over 3,000 Twitter followers at this point in time. And last year, we increased by 52% the number of tweets that we sent out in order to be of interest to our followership. So since I was last before you, I have issued 9 investigation reports under the Act and 4 under the Code. We've always been able to complete our analyses and conclusion in less than 1 year, which was one of my initial goals when I was appointed back in early 2018. I set out this goal to complete unless it was exceptionally complex or unless there were exceptional circumstances. Any study, any review, any examination that we do under the Code or the Act within 1 year. So we've managed to do that in the 13 reports issued in the last 2 years and 18 since I've been in my position in January 2018. And I hope you'll share my view that we have produced quality work each time. So I'm here today, and I'm pleased to let you know that we currently have no investigation undergoing under the Act, no backlog. Therefore, we're ready to accept the next complaint or the next situation where I have reasonable grounds to start an investigation. We have a couple under the Code still ongoing. In fact, I'll be tabling a report before the House rises. As a result of an investigation under the Code. And we receive a fair volume of complaints and informations, as you wish, from the public, from the media. So we've reviewed over 100 files, 100 situations where my staff has reviewed incoming information to determine whether we should investigate. So there's a good flow of information that comes in all the time. Au niveau du budget, parce que c'est ça qui nous amène ici.
With respect to the budget, which is the reason for this meeting, we have a budget of $670,000. That is up over $500,000 from when I was last here regarding the main estimates. Last year, we used it to fund 3 positions and maintain our IT system. Since the creation of this office 14 years ago, the budget has risen from about $1.6 million more compared to its initial budget. Let's discuss the pandemic. As we've heard, some patios are opening tonight. The pandemic hit us abruptly, like for everybody else. I had a medical issue a few years ago, and so I was more vulnerable. I left the office not knowing when or how I would get back to it. We all thought it was going to take a couple of weeks. We took certain measures. We were lucky because we were in a situation where each employee had a tablet, could work from home. We took measures for each employee with respect to Wi-Fi availability. We provided equipment in order to facilitate remote work, ergonomic setups. It cost us $28,000 for 51 employees, whether we're talking about supplies, paper, pens, etc. and that was offset by the reduction of other costs, like costs such as printing. So we've saved many trees and postage. Employees generally seem to enjoy remote work, so we have a good working environment. We work with technology, like Parliament has done, to make sure that the lines of communications are open.
All this work, of course, is accomplished because of the 50 people who work with me, and who have been very, very good through the pandemic. So we did not actually measure productivity because we have no backlog in any respect anywhere in the organization. So we've been able to cope with the volume of the work in spite of the pandemic, and while trying to minimize and help employees as much as possible vis-a-vis the maintenance of a good balance and a good mental health situation. So, Mr. Chairman, that's what I had this afternoon, and I would be pleased, of course, to answer any question that members may have.
Thank you, Commissioner. We're going to turn to Mr. Barrett for the first 6 minutes. Mr. Barrett.
Thanks, Chair. Thank you, Commissioner, for joining us today. I start by saying that I appreciate the volume of work that you've had to undertake since you last appeared before the committee. And while I do have a lot of questions that I would like to ask as a matter of context on any of the number of reports that you've undertaken with respect to public office holders, particularly cabinet members, including the now former finance minister, the prime minister, a couple of times. I'm going to focus my first questions on the Trudeau 3 report, the third report into allegations that the Prime Minister broke the Conflict of Interest Act. And my first question is with respect to the actual process that you undertook in the report. So I note that a few individuals, Rick Tice, who's a policy and cabinet affairs advisor in the Prime Minister's office, Amit Pal Singh as well, were interviewed by you when you did your report. And I'm just wondering if these individuals volunteered or were requested to provide virtual or face-to-face or virtual in place of face-to-face interview with your office.
The way it works, Mr. Chairman, I'm afraid the answer is neither. They basically were asked to come for an interview, and they agreed to come. So that's usually the case. Very, very few people actually volunteer for an interview. So that's how it goes. We basically review the documentary evidence. We determine what more information we need from anyone, and we call witnesses. I have the power to subpoena people. I did not have to issue any subpoena since my appointment back in early 2018. So they did come voluntarily, but as a result of a request that we had made of them.
Okay. So in your study, in your report titled Trudeau 3, I again note that Mr. Tice and Mr. Singh were asked to provide interviews, but I note that Prime Minister Trudeau was not. Are you able to provide us the context in which Mr. Trudeau did not provide an interview in your preparing the Trudeau 3 report?
Monsieur Trudeau was not asked to provide an interview because we had enough material using the some 40,000 pages of documentary evidence. And we also required the Prime Minister to give us a sworn statement in writing to fill some of the information gaps that we needed to fill, but it was not actually necessary to require an interview with the Prime Minister, so we didn't do so. And that's our general practice. We only ask somebody to come to an interview when there is a need to do so. An affidavit is just as good, as you would know, Mr. Barrett, as an interview. So that's why it took place that way.
So for context, through you, Chair, to the Commissioner, and I appreciate that answer, in preparing the Trudeau Report 2 and the Trudeau Report 1, were interviews conducted with the Prime Minister?
Yes, they were conducted, and it's so indicated in each of the reports at Appendix A. Mr. Trudeau is listed as a person who was interviewed in both Trudeau 1 and Trudeau 2.
And again, for my context, I'll just turn quickly to the Morneau Report 2, which did find that Mr. Morneau had violated the Conflict of Interest Act. Was Mr. Morneau interviewed by your office?
No, he was not. He was at Appendix A of the report, or Appendix 1. There's only one appendix, I guess, and it lists the. So we did, for the same reason as we did not have to require the Prime Minister to come for an interview, we did not have to require the former Minister of Finance either. We had enough by way of documentary evidence and a sworn statement as well that we required from Mr. Morneau through his solicitors.
Turning to another part of your investigation, I'm just wondering what your office, what information you were furnished with or uncovered with respect to the Canada 150 events that took place on Parliament Hill. You'll recall, Commissioner, that those events featured the Prime Minister's mother and were paid, and the We organization was given a $1 million contract to undertake those activities. Was that part of your investigation?
It was part of what we had to look at by way of background to determine the nature of the relationship between the Trudeau family and We Charity. But it was not the focus of our examination. It was contextual information which was useful for us to know about in order to properly assess the nature and type of relationship.
And did you uncover any evidence, or were you presented with any evidence that demonstrated that Madame Trudeau was not paid to be a speaker at that event? And I will have to, and I'll ask if you can engage in a hypothetical, and that is to help folks understand the difference between the appearance of a conflict and an actual conflict. If in that case, Madame Trudeau there had been paid, would that have demonstrated or put the Prime Minister in a position of a conflict of interest?
Madame Trudeau has been paid. We've established that throughout reviewing the documents. Madame Trudeau, the mother, has been paid on several occasions by We Charity. Madame Trudeau, the wife, the report details, what we have by way of background information. So in 2017, at the event that you're talking about, I don't actually recall whether we had any evidence that she was paid or not paid. But I can, of course, provide the committee with that information if it's available to us. I simply don't recall that.
Thank you, Mr. Barrett. Your time is up. We're going to go to Ms. Tanzio now for the next. Yes, Mr.
Chair,
Barrett.
just before moving on, I appreciate the Commissioner undertaking to provide that information, and just ask that you would make a note of that.
Yeah, thank you. I think the Commissioner did indicate that he would supply that, and so we do appreciate that. Ms. Latanzio, will turn to you now for the next 6 minutes.
Thank you. Thank you, Commissioner Dion, for joining us today. I understood that budget has been increased, but despite that, what are the main challenges? Monetary, of course, I know that it's 1.6 million has been accrued in the budget, but or otherwise that are facing the Office of the Conflict of Interest and Ethics Commissioner over the short and medium terms.
I think our greatest challenge is still to properly communicate, explain to MPs and to public office holders their obligations under the code and the act. These instruments, these documents are complex. The vast majority of people who are regulated by the act and the code have a relatively shallow understanding because it is complex. Unlike me, they don't spend their life thinking about these things. So we're trying to find better ways to provide guidance through documents we put on the web, through videos, through webinars, because I believe that, first of all, each MP and public office holder is the first person responsible for making sure they comply with these instruments. But our job at the office is to assist them in doing that. And the best way to avoid problems is to make sure that we have an educated group of people who actually are able to identify the situations where they should consult with us. We receive a fair volume of consultations as it is. We had, we had 2,000 consultations by public office holders in the last fiscal year, and 500 from MPs. But sometimes, MPs call about things that are menial and maybe don't call about things that are really important. You need to have the reflex to identify those issues. And I understand the member is a lawyer, and I don't know if the member has had a chance to go through the documents, but they are short but relatively complex and vague as well at times. So that's the greatest challenge that we still have to demystify, explain, vulgarize. I don't know what other words to use to describe what I'm trying to get at.
Thank you, Maître Dion. So you've identified, the difficulties perhaps that are incurred on a daily basis in terms of making distinctions. And I think that also the number one is also, there's a confusion with regards to the distinction with the Act and the Code. But that being said, how do you plan on measuring the progress in this regard, in terms of making more people aware and maybe making more people cognizant of what their responsibilities and obligations are?
We do measure attendance at the events that we organize, educational events such as the ones I've mentioned during my opening remarks. So I was very, very pleased when we attracted 302 people to a session in each French and English to deal with the subject matter of recusals a few months before we publish the Trudeau 3 and Morneau 2 report. So it was topical. People registered in large numbers. And so that's one way, attendance. Second way, of course, is the degree of contravention. So we'll have to see how it evolves. So if we have a wave of contraventions, it will probably go to indicate that we're not very successful in our efforts. On the other hand, if we have very few contraventions, it's one factor. That's why we do education, in order to prevent problems. And also, we will do a survey at one point in time of the regulators to determine whether we're using the proper means to communicate with them as well.
So based on what you just said, and based on the fact that you have no backlogs under the Act and just a couple under the Code, I would conclude, based on what you just said, that things are going pretty well. Some of your provincial counterparts have a dual mandate, that of the Registrar of Lobbying and of Conflict of Interest and Ethics Commissioner. You have signed an agreement with the Office of Commissioner of Lobbying of Canada with respect to education and outreach, given some of the links between the two mandates. Would you see any benefits, financial or otherwise, in merging the two federal offices in one?
No, I have never studied the question in depth. I know that any major reorganization, and this would be major for the staff, at both offices, if there was to be a merger. My experience in several places, in almost 40 years of public service management experience, it is very unsettling. It takes months, if not years, for an organization to stabilize after a major reorganization. And I really wonder whether it would be worth the effort to do that. We currently have a good degree of cooperation with the Office of the Lobbying Commissioner. We have our budgets in the global scheme of things are very, very small. So it's probably not worth the effort. But that's my superficial opinion, not having studied the question at depth, in any depth.
I appreciate your answer, your sincerity in your answer. I'd like to now bring you to the strategic plan of 2018-2021. The office will focus on certain key priorities, including the modernization of technology and information management structures. How is the modernization, unfolding? And given the cost of technology, does such a modernization require unusual or additional expenses?
It has proceeded. Sorry.
Madame Lattanzio was out of time, but we'll allow you to answer the question, and then we'll move on to the next questioner.
Mr. Chair, I'd like to first of all underscore the excellent services that we receive from the House of Commons in relation to IT services. We are really lucky because we belong to the Parliament Hill, and we are receiving excellent services from this group. So we were able to modernize without incurring any significant additional expenditures, but not of great significance. And it's well worth the investment as demonstrated during the pandemic. We're much more nimble than we would have been 3 or 4 years ago without those improvements.
Thank you. We'll turn to Madame Gaudreau now for the next 6 minutes.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Chairman. Commissioner, I'm pleased because I gathered from your initial comments and the questions posed by my colleagues, you really did answer the questions about your mandate and the budget, so thank you for that. But I'll take this opportunity to perhaps leave the rest of my time to my colleague, Mr. Fortin, so he can ask you a few questions, if that's all right.
Monsieur Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Good day, Commissioner. Thank you for being here. Your mandate is not an easy one. Investigations on ethics matters must be stressful at times, and you're doing a good job of it, from what I can gather. My first question, Mr. Dion, is this. In your view, does the current Act, as it stands on conflicts of interest, in fact, should it be updated? Should there be amendments to make it more effective? Answer. The way in which the question was asked, yes. Would it be worthwhile? The Act, it would be worthwhile to put things in those terms. I would say, however, that's based on the way the question was asked. But I would say the Act works well right now, but there are things that could be improved. When Parliament has time to examine this issue, I think that would be time well spent, and then I'll have some suggestions. Thank you, Mr. Dion. In your Trudeau 3 report, you raised the fact at the end of the report that Mr. Trudeau himself recognized that he was in a situation of an apparent conflict of interest, but you state that the appearance of conflict of interest is not covered by the Act. To my knowledge, it is in many other acts or other regulations on conflicts of interest, but not in this particular case. In your view, would it not be worthwhile to amend the current Act so that the appearance of conflict of interest also be covered, and then people would have to recuse themselves when there is a conflict of interest, even an apparent conflict of interest? Answer. I'd like to reiterate, I think we said this in the report, that it was a conscious choice in 2006 not to include the appearance itself of conflict of interest. When you look at parliamentary debates, an amendment proposed by the Senate in 2006 aiming to include the appearance, the government at the time chose not to include that notion. Would it be advantageous to do so? I haven't studied the question in depth. I studied it somewhat because, of course, I did expect this type of question. It would involve some risk because you have to avoid this sense of paralysis in a way. Politicians know many people. It's also a very subjective thing. What one person thinks is an appearance of is not what another person will think is the appearance of. So it's intangible, subjective, abstract, and these are the types of things that would have to be studied in depth by a parliamentary committee before we arrive at a conclusion as to whether it is a good idea and whether it's practical. In practical terms, whether we could take certain measures. Answer. Question. There are provisions of this type in the Bar Act. Judges before the courts have to recuse themselves, withdraw. Seems to be really a rather common practice among people who have decisions to make, not to put themselves in situations like this. Because if there is an appearance of a conflict of interest, then it would mean that there could be a lack of confidence in the justice system. In in this particular case, Mr. Dion, the appearance is rather strong here. Mr. Trudeau, his family had received millions of dollars, or at least hundreds of thousands of dollars of contracts. You know, his wife, his mother, his brother, Mr. Morneau, also his daughters worked for We Charity. These people were aware of the fact that it was a conflict of interest. Mr. Trudeau had even postponed the decision to a further study because he wasn't comfortable with sitting on this issue. They granted the contract in that circumstance with no call for tenders. Experts have said that when there is no call for tenders in these kinds of things, you have to be even more vigilant. So not only was there no more vigilance, there was actually less vigilance. There was no diligence, no accounting check, no check whatsoever. And people negotiated directly with the government, and that's evidence, without even being registered among lobbyists. And yet the contract was given to We Charity Foundation that is empty, has no assets to guarantee these. There was no financially. The government granted a $500,000 million contract with up to $800,000 without proceeding in a regular way for the only reason, and the only reason was because the Kielburgers were known to the Trudeau family. They had had a relationship since the early 2000s. Does this not strike you as such a strong appearance of a conflict of interest? That I understand that I'm not saying you did a bad job. I realize you have to work with the Act as it now stands, but is this not a situation that is so egregious that you'd have to predict this type of thing, that the appearance of such an egregious appearance of conflict of interest be addressed? Because otherwise it will be difficult to maintain the trust of the public in the current government. What do you think of this, Mr. Dion? We were talking about the reflex of a public office holder or a member of parliament. In the case of the member, the code provides for an appearance as being something that can be sanctioned. The only case where things may be different is in BC. We looked at issues summarily. No other province has that situation where there can be sanctions under the code of the province or territories. So it has to be looked into. The issue remains. The question was asked in 2006. The decision was made, and one day we'll have an opportunity to take part in a debate on this.
For the next 6 minutes.
Merci.
Mr. Angus.
Thank you so much, Mr. Dion. It's always a pleasure to have you come to our committee. You don't come often enough, I think. And I want to congratulate you. I think your reports are always extremely diligent. I don't always agree with them, but I find them very fascinating and I reflect on them. I want to ask you about the Morneau report because it really, to me, shows a staggering level of insider access and answered many of the questions we were trying to get figured out at our committee. In sworn testimony to the committee, the Kielburger brothers stated that one of the reasons they opted not to register to lobby was because they said, quote, "It was unusual for us to be spending any significant time with the federal government." And yet, in your report, you state that Mr. Morneau's office, quote, "had an unusually high degree of involvement in files relating to We," that there were frequent communications between members of Mr. Morneau's ministerial staff and We representatives, that Mr. Morneau gave We preferential treatment by permitting his ministerial staff to disproportionately assist it when it sought federal funding. Then you say, "I believe this unfettered access to the office of the finance minister was based on the identity of We's representative, Mr. Craig Kielburger." So would you say that unprecedented, to me, access to the finance minister's office created the conflict of interest for Mr. Morneau and certainly helped exacerbate the scandal that was the We scandal?
That's why we determined that, in my view, they were friends within the meaning of the Act. And that's why we found Mr. Morneau in contravention of a couple of sections of the Act, because Craig Kielburger and Mr. Morneau were friends, in my view. The word friend is not defined in the Act. It's up to me in each and every situation on a case-by-case basis to analyze the indicia of the relationship. And in that instance, it was the determination I made after some reflection, but it was relatively easy to determine that they were friends.
Yeah, I guess to me, it's beyond the area of question of them being personal friends and going to brunch together, but that I find it shocking that their relationship, the way they treated staff in the finance minister's office to say, hey, girl, that sense of that they were that welcome in there to say, hey, girl, to federal staff, and that when Parliamentary Secretary Jennifer O'Connell asked why she was being asked to attend a meeting with Craig Kielburger, she was told, this is important to Bill, and Craig is not often in town. It is purely listening mode to keep him happy. So who are they trying to keep happy? Craig Kielburger or Bill Morneau?
I don't know. We can each read this and make our own determination. But it was one of the documents that we reviewed.
Okay. I find that
to keep him happy, my interpretation is as good as yours. Whether they're talking about Craig Kielburger or Bill Morneau, I don't know who is him.
But highly unusual for the finance minister's office in a G7 country that they're saying they want to keep Craig Kielburger happy, if that's the case. I want to also
that's what I thought. That's why I determined them to be friends.
I'm really pleased you put that in there because it stands out that there's something wasn't right there. The Kielburgers stated under oath at the Finance Committee that they said any allegation and false claim that we would have financially benefited as individuals is simply false, and it is incredibly insulting that you, the committee, will not accept our answer on this. And that you write, there is no doubt Mr. Kielburger's interests would have been furthered had we administered the CSSG. We would have acquired a significant financial interest, and the Kielburgers' involvement is so prevalent that the organization's interests are also those of its co-founders. And you have stated on a number of occasions in your article, in your report, that Mr. Morneau was inappropriately furthering the private interests of Craig Kielburger. Can you explain that?
Yeah, we weigh every word we put in those reports, very carefully. And so you read some excerpts, and I recall they're pretty powerful excerpts, and we did weigh them very carefully before writing them, and we have the evidence to support that. So receiving $43 million to manage a program, of course, will unavoidably improve one's situation vis-a-vis the ability to retain staff, for example, the ability to borrow money, and so on and so forth. So that's why we came to that conclusion.
Okay, because I think, and again, there were many things that just seem to just jump right off the page. And one of the things that I found most shocking was this allegation that ministerial resources, again, the resources of a finance minister of a G7 country were used to hustle gigs for the Kielburgers. You say, quote, evidence shows that Mr. Morneau and his staff assisted WE by reviewing its funding proposals, introducing WE representatives to ministerial staff and relevant departments, as well as intervening on their behalf at federal, provincial, and municipal levels. I mean, if the finance minister of the country is calling down into some town council to get a gig for Craig Kielburger, would you not agree that that is highly, highly inappropriate behavior?
Of course, I agree, because that was our finding. It was highly unusual, and it's also inappropriate in my view.
And inappropriate. Thank you very much.
Thank you, Mr. Angus. We're going to turn to Mr. Gourde. Mr. Gourde, for the next 5 minutes.
Merci. Thank you, Mr. Chairman. Thank you, Commissioner Dion, for being here. It's always a pleasure to have you here and to speak to you. Earlier on, something concerned me. You said that members of Parliament were subject to this certain aspects. You say there are ministers, parliamentary secretaries, senior officials would not be subject to potential sanctions in the case of an appearance of conflict of interest. But the ministers and parliamentary secretaries are also members of parliament. At what point in the act do they no longer fall under that clause? The key is it in the context of their duties as a member of parliament? When a person holds both roles under the code and under the law, was the individual acting as a member of parliament or as a minister? Then if it's a minister, it's the act that applies. If the person was acting as a member of parliament, the code applies. So each time you have to look at this. In the case of We Charity, clearly it was as a minister that Mr. Morneau and also Mr. Trudeau were acting, not as members of a riding, representing a riding. Some individuals are still subject to that same act, some parliamentary secretaries. Why is it that they would not have to comply? Or you have to look at this context. In what context did the parliamentary secretary act? Was it in the context of his role as a parliamentary secretary or as a member of parliament? When a person is consulted under certain issues, the person would be answering in the context of being a member of parliament. So this often happens. You have to really make a determination under what role, what policy or what act or code applies. So it's complex. You have to develop a reflex, and it's important to try to avoid these types of things. When you talked about sanctions, potential sanctions for members of parliament, what are we talking about? We're talking about fine or what? Mr. Chairman, only the House can impose sanctions on a member of parliament. The code says that when I investigate on a case, an allegation of a contravention of violation of the code, I can recommend a sanction. Since the start of the creation of this code in 2004, I think there's been one instance where we recommended a sanction. I did it recently in the Maloney case. Of course, it is up to the House to make these determinations. For instance, there could be a suspension of a member of parliament for a period. The House has full authority within its realm to decide of the penalty. My only role is to make a recommendation in the context of the code on the conduct of members. Did you recommend a suspension with or without remuneration? In his case, I asked for excuses to be made or apologies to be made to colleagues. What was concerning to me was that out of the 338 newly or recently elected members, there was only one that had not issued those confidential documents, and I recommended that this person express his apologies, whereas everybody else had done it. He should have done it, and so he did, in fact, apologize on the day of the report, if my memory serves me correctly. So this is an annual exercise, inaudible, and then this has to be done annually. Do you think this should be amended, or should it stay as it is? Answer: I think it's kind of like filling out your taxes with the CRA. Every year I get the same question as to whether whether I am or am not still married, whether I still live in Quebec. Once a year is not too much, and it also prevents oversights. If you have to go over a form and ask yourself, hey, do I have a new car? Do I have a new car loan? I think it avoids people forgetting. I think it avoids an oversight. I think the current code works well, that there would be this requirement to repeat the exercise every year. Question. In previous years, you would have the history of the previous year's report. In this case, we now have a full report that we have to issue. Have things really changed under you? Answer: yes, it has, because I want to respect not only the spirit but also the letter of the code. It was clear that that's what needed to be done. That's why I changed that. Thank you, Mr. Dion. I have no further questions.
Thank you, Mr. Gourde. We're going to turn to Mr. Fergus now for the next 5 minutes. Mr. Fergus.
This is inaudible to the interpreter.
Yeah, Mr. Fergus, I think that.
Excusez-moi,
very
il y avait un
good.
problème avec le micro. Oui,
Please, again, Mr. Fergus.
Vous êtes très gentil, Monsieur le Président.
Thank you kindly, Mr. Chairman. I'll do so. Good day, Mr. Dion. It's a pleasure to see you before the committee once again. I appreciate the work that you do, you and your team. On several occasions, I had an opportunity to turn to you for to your colleagues for advice, and I can tell you that the response was quick. They responded quickly to my concerns, and I really appreciate that. Mr. Dion, I'd like to get back to the Conflict of Interest Act. And I'd like to get back to a couple of questions that I have, specifically with respect to the Trudeau 3 report. Section 6.1 of the Conflict of Interest Act indicates that it is prohibited for any public office holder to take a decision or take part in a decision-making process in the context of his duties if he knew or should reasonably have known that by taking this decision he could find himself in a conflict of interest. You found that the Prime Minister had not contravened or violated that section of the Act. Please explain what led you to that finding.
D'abord, merci.
First off, thank you for your comments about the quality of services you've been receiving from our offices. Oh, we have a service standard where we have committed to respond within 3 days after a public office holder or member contacts us. We manage to do that in 90% of cases. The non-contravention under Section 6.1 of the Act has to do with the fact that, in our view, the relationship between the decision that was made and the impact it can have on the situation of Mr. Trudeau's family, that line, that it couldn't lead to that determination as to a conflict of interest. If I summarize, it's difficult to summarize in a few words. Mr. Trudeau, of course, was aware of the fact that his brother and his mother had taken part in many activities for We Charity. Mr. Trudeau said, he told us that he did not know the nature of the relationship, nor the compensation, or whether there was compensation, and at what level. I believe Mr. Trudeau. And so I found that there was no violation under Section 6.1, given the link between the contract and the compensation received by Mr. Trudeau's family. In the same vein, in Section 7 of the Act, we see that it is prohibited for any public office holder to grant, in the context of his official duties, any favorable treatment to an individual or an organization on behalf of another person or another organization retained to represent one or the other. Did the Prime Minister act in violation of Section 7? And did he provide preferential treatment to this charity? No, there's a clear conclusion, clear finding in the report. The answer is no, given the lack of an existence of any clear link, relationship between Mr. Trudeau and Mr. Kielburger, unlike the situation with Mr. Morneau. So there is no existence of a relationship under Section 7. Question. So you did have this finding based on over 40,000 pages of evidence that you've looked through. Answer. The process is quite is the way that it is. If you don't mind, Mr. Chairman, when we start an investigation, we receive a complaint. We have a completely neutral position as to whether or not there has been a violation. I have no opinion. I need some percent of the time. We collect as much information as possible. We ask people to send us information, and we are very broad. We give massive periods of time, massive fields of information. We've received full cooperation. It's not always the case. In this case, we did. We received mountains of documents. And of course, when you go through all of this information, when there is no indication that it must be because there was no relationship. Out of those 40,000 pages, there was no evidence of any particular relationship, personal relationship between Mr. Kielburger and Mr. Trudeau. I think it goes back to 2012 when Mr. Trudeau became a member of Parliament.
Fergus, your time is now out. Madame Gaudreau will turn to you again for the next.
Oui, je crois que mon collègue, Monsieur le Président, avait encore.
Mr. Chairman, Mr. Fortin.
For the next 2.5 minutes.
Merci, Monsieur.
Thank you, Mr. Chairman. Thank you, Madame Gaudreau. Mr. Dion, you've just said a few moments ago that you believe Mr. Trudeau when he said he was unaware of the nature or the extent of the benefits that his family had received from We Charity, and that because you believed him, you found him innocent. If Mr. Trudeau had consulted you beforehand, let's say when he postponed that meeting to a couple of weeks later because he wasn't comfortable, because he was afraid of a conflict of interest, if he'd consulted you and had said to you, listen, I'm not aware of the extent of remuneration or benefits to my family members, would you have advised him to get informed before he made that decision? Or would you have said to him, well, listen, if you don't know, close your eyes, turn a blind eye to this and move on? Answer, Mr. Chairman, hypotheticals are always perilous questions, not to ask, but to answer. The advice we give people with respect to recusal is, if you're in doubt, recuse yourselves. I would certainly not have said the second option that you just announced. You know, we say to public office holders, if you have a doubt, then you probably have a good reason to recuse yourself. It's always more prudent to do that. I don't know, of course, what I would have done if Mr. Trudeau had consulted me in that particular scenario that you're hypothetically putting forward. It would be the same situation. We have nothing to gain from getting involved in something where there's some doubt as to the objectivity of our decision. Yes, and if I get back to, I understand this is hypothetical. I'm not really trying to go further with it, and perhaps I'm not quoting you properly here, but you stated that Mr. Trudeau did not know. And you said, okay, well then there's no contravention of Section 7. But if he had discussed this issue beforehand, the same situation, you would have advised him to get some advice and not take part in the decision-making process. Am I correct? That's what I would advise, yes. And let me get back to the question asked earlier. In that regard, given the extent of this issue, would it not have been wise to amend the Act so these types of situations not recur? In your view, I understand you don't want to engage in hypotheses like this or assumptions. As the Ethics Commissioner, however, wouldn't it be wise to avoid situations of a conflict of interest or appearance also of such egregious conflict of interest in the future? And so there are many things we take into consideration with regulatees, filters that are in the public registry. You'll notice that there are a number of ministers and other public office holders who have established a filter to avoid entering into contact with any situation where they would have to decide on anything regarding an entity or person. Question, so your
time is out. I do apologize. This is the problem with these short turns. We're going to turn to Mr. Angus now for the next 2.5 minutes. Mr. Angus.
Thank you, Mr. Dion, for coming. And on behalf of the Canadian people, I would like to thank you for this report that really shows the shocking level of insider access that's happening in Ottawa. What we began in the study with the We Charity issue, we thought we were dealing with the crisis of the pandemic, and quick decisions had to be made, and a few mistakes may have happened. But what you lay out is a pattern of inappropriate breaches of all the rules that should be in place to protect the public interest. And this goes back, this is the operating culture between the Kielburger brothers and the Liberal government. June 2017, Mr. Kielburger and Mr. Morneau meet, and they decide that the finance minister's office is going to help them get their funding for their accelerator hub, that they are going to start using public resources to hustle for the Kielburgers. November 2017, they're establishing pre-budget consultations in the Kielburgers' offices, and the Wee brothers are promoting this for the finance minister. In December 2017, separate emails to various chiefs of staff from Bill Morneau's office to ministers within the government of Ontario, introducing Craig Kielburger as a, quote, dear friend, a great local partner, asking the provincial counterparts to make time to meet with Mr. Kielburger, and that when they get the provincial funding, Mr. Morneau's office is the first one notified, and then he calls his bestie, Craig Kielburger. I put it to you, Mr. Dion, we would never have learned this if it hadn't been for your investigation. And so I take from that for other groups like the Kielburgers, why bother to register as lobbyists? Because they were able to fly under the radar. They were able to have insider access. All the normal rules were able to be broken. We don't know if they had this access in Minister Chagger's office or any other minister's office. We just know from your report. So how do we stop this abusive insider access of the public interest? How do we ensure if they're not going to bother to be registered to lobby, if there's no lobbying investigation, the Kielburger brothers and their like can carry on and do what they want? It's not right.
It's one of the, I think, uses of such a report is to analyze whether it's, and for others to analyze, because my role is limited to determining whether in a particular fact situation there was a breach of the Conflict of Interest Act. But I hope these reports will also serve policy people within the government and within political parties to try to create systems that in the future will prevent the repetition of such behaviors. But it's not my role to do that. I'm not equipped nor resourced to do that. So.
But thank you for your findings.
Thank you. I appreciate it.
Thank you, Mr. Angus. We're going to turn to Mr. Carey now for the next 5 minutes. Mr. Carey.
Thank you very much, Mr. Chair, and thank you very much, Mr. Dion, for being here. I was brought into this committee kind of halfway through, and there's some questions that I think you might be able to help me answer. I want to talk about the Conflict of Interest Code as it relates to the Trudeau report. Now, the code section 2E says that like a member of parliament, any member of parliament should not accept a gift or benefit seen to compromise personal judgment. 14.1 says that it should not be reasonably seen to have been given to influence the member, and it could be related to attendance at charitable or political events. Now, Mr. Dion, with the Trudeau report, did you get any evidence of the value of the promotions and branding that Me to We, not the We charity, the for-profit company that the Kielburgers own, the value of the promotions for branding that they charge corporations and companies for their attendance and promotions at the Me to We events, We Day?
That's an aspect, Mr. Chairman, that I believe we have not examined at all because it was not within the scope of our, it was not necessary in order to determine whether there was a contravention of sections 6, 7, and 21. So we have not looked at this issue whatsoever.
Okay, well, thank you for that. I don't see how you could have looked at it because when I asked the Kielburgers the questions, they hemmed and hawed, but I don't know if you're aware of it, Mr. Dion, but the Kielburgers at their for-profit company charge corporations to come up on stage with them to be vetted by We organization to say that they're a good guy, literally hundreds of thousands of dollars for that. But Mr. Trudeau received that for free. And when I look at the code, section 2E, and 14.1, it may not have been in the scope of this investigation, but For me as a politician to go up on stage, to be presented to tens of thousands of future voters, being told by an organization that has been built up as the wonderful We organization, that I've been fully vetted and supported, that's of great value to me. And they were actually charging corporations. This was not a donation to a charity. They actually paid for advertising and branding hundreds of thousands of dollars. They even made a promotional video for Mr. Trudeau, and I asked them how much the value of that was. And of course, they didn't tell me, but we got just a few weeks ago. So you could not have possibly known the value of that video that they gave to Mr. Trudeau at these events. It was $121,000 for 10 videos, and his was one of them. So if we just do a division, it would be $12,000 for his video. But if you've ever seen it, it's a very good, snazzy video, a promotion that any politician, if they received that, would be extremely high value product that he received. And my question for you would be, if you'd known that Mr. Trudeau had received from Me to We, a for-profit organization, literally benefits that a private company would be paying hundreds of thousands of dollars, a promotional video that was very close to the election, worth at least $12,000, would that be something that under the code, Section 2E or 14.1, would be seen as questionable?
Again, it's an hypothetical question. It's always difficult to answer such questions. At any point in time, if a member of parliament believes that the code has been breached, they can actually make a complaint about the alleged behavior and the alleged breach. But I would remind the member that we always look at whether the subject matter of the complaint really relates to the person's position as a member of parliament or to the person's position as a minister governed by the Conflict of Interest Act. So the short answer is if and when I have to analyze it, I will, and will determine whether there are reasonable grounds to believe that an inquiry should be launched. But
okay, well, thank you very much, because like I said, there's no way you could have known the value of that when you were writing your report. And to get the Kilburgers to actually come to committee to answer some questions was extremely difficult. And we did not even receive a written response to that value of the video until just within the last couple of weeks. But it concerns me, Mr. Dion, because this code, I think, is very clear where it says, do not accept gifts or benefits seen to compromise, especially given the relationship of the Trudeau family and the size of the contract that these Kilburger brothers were searching. That's a lot of money. If I was a company paying Me to Eat, like if it's a charitable donation, that's one thing, but this was their for-profit company that companies paid. Mr. Trudeau received the exact same benefit and didn't pay anything for that. So maybe that's something that we could investigate a little bit further. Mr. Chair, how much time do I have?
You are out of time. I think
I'm very sorry.
You don't have time for it. Mr. Dion, was there anything that you would like to respond to with regards to those questions?
No, Mr. Chairman. I think I have responded. Yeah.
Perfect. Mr. Dong, we'll turn to you now for the next 5 minutes. Mr. Dong.
Thank you very much, Chair. And I want to thank the Commissioner for coming today and your hard work and your staff's hard work in putting together these two reports, given the time frame. For the record, did your investigation find that the Prime Minister intentionally offered the We Charity preferential treatment?
No, we found the opposite if you read the report.
Thank you. In your report, you cite the former Integrity Commissioner in Ontario, Gregory Evans, that stated that, I quote, one person's perception of another's conduct is purely subjective assessment influenced by many factors, including the interest of the individual making the assessment. It is not the proper criteria by which the conduct of a legislator should be measured. Throughout the last several months, we have seen opposition party members attempt to pursue their own investigation of the Prime Minister in several committees. In your view, was such a partisan investigation yield effective or truthful report for Canadians?
I'm afraid it's not for me to have a view on that. It's two different approaches, basically. So Parliament and its committees have a role. The commissioner has another role, and we have completely different objectives and modes of operation. So when I proceed to an examination under the Act or an inquiry under the Code, I do so with the focus being on what the Code requires me to do or the Act. And we did follow with interest what was going on before committees, but we had to essentially, it was a source of some inspiration, if you wish, but we had to validate. We did not rely on anything that was only said before a committee. We had to basically go and ask again, because we were denied the permission to use it by the Finance Committee.
Yeah,
so our failure to give the permission was interpreted as a denial of permission. So we were on parallel tracks, and we have very different objectives and very different modes as well, or methods. And I respect the methods used by Parliament, and I wish Parliament respects the method I'm using in conducting my examinations.
Very well. That was the same concern we heard very early on in our study by the former commissioner, that we shall not, by any chance, contaminate your investigation by doing a parallel study. Following the release of your report, the Conservative leader came out and decried that the system is broken. And it's good that today that you reminded us it was the previous Harper government that in 2006 that deliberately exclude the perceived conflict of interest, that part of the Act. Respectfully, I see in your report that the system worked and is working. But I worry that this type of language the Conservatives used only to serve to break down trust in our public institution, including office of Parliament. Would you agree that the work you produced points to a broken system, as described by the Conservative leader?
You see, my role as an agent of Parliament is to implement the law as it is, not the way some people wish it should be. And the views I have as to how the law should be changed, I think will only become of interest to Parliament when and if Parliament looks at it. So at this moment, I think I said earlier during this presence this afternoon that in my opinion the Act works as it's currently written. So therefore, it probably indicates that I'm not in agreement that the system is broken. But anything can always be improved, and it is very subjective, as pointed out by Mr. Evans in the quote that you gave us, the member gave us a minute ago.
Okay. Your report exonerates the Prime Minister from any wrongdoing with regards to We Charity. I would appreciate your thoughts on what politicians, be it MP or minister, can do to avoid even appearance of such a conflict of interest in future to ensure the continued confidence in our system.
It's about being vigilant. I think I've already referred to that a few times, being vigilant to identify any situation. And it's easy to say, not easy to do when you have to make hundreds of decisions each week. But be vigilant. Try to make an effort to, and do not fall to the temptation of deciding nevertheless because it's urgent or because whenever there is a doubt that there is possibly a potential conflict of interest, you should stop and analyze and recuse. It's always the best approach. When in doubt, recuse. Nobody will blame you for having recused. You could be blamed if you fail to recuse in a situation where you should have under Section 21 of the Act.
Thank you very much. And I appreciate the fact in your report you acknowledge the extraordinary circumstances under COVID that decision makers of public office has to make a very expeditious decision. And and I take your advice on being extra vigilant when you are at the position of making these decisions. You got to be very careful not to have appearance of conflict of interest. Thank you very much.
Thank you, Mr. Dong. You are out of time, and that's an appropriate end to the the time with the commissioner. And so, Commissioner, we want to thank you for your testimony today. We thank you for being with us, and we know you've been very, very busy over the last number of months during difficult and trying times. And so we, like Mr. Dong, commended the government. I'd like to commend you, Mr. Dion, for undertaking your work diligently and completing these reports in a timely manner, so committee members and parliamentarians, Canadians generally, can review your work. And so thank you so much. Colleagues, yeah, thank you, Mr. Dion. We will we'll allow you to go we thank you for being here. We will now allow you to leave, and we're going to move to the votes on the estimates. And so, committee members, there's a couple of ways to do it. I think what we'll do is just move through the votes. There are 1, 2, 3, 4, 5, 6 motions that we do have to adopt. And so just a reminder to members that it is possible to vote down the granting of these amounts. We can reduce them, but we cannot reduce them further than what has been granted through interim supply. And so if there's a willingness for committee members to proceed to the votes, we'll quickly do that, after which we can move into committee business. But I will start reading through the motions, and we will, if anybody opposes, I think that we'll assume that there's unanimous consent to carry on, unless somebody opposes, and then we'll move to a vote by head count. So shall vote 1 under the, pardon me, is somebody jumping in? Mr. Barrett.
Yep, Chair. So you mentioned that you have a suite of items for the committee to vote on. I'm just wondering if has been the practice in the past, if you could, for the record, read the items, but I would suggest that it would be expeditious and would also serve the ultimate purpose for them to be grouped as one item, and that should the committee wish, that they be passed on division.
We can certainly do that. That is definitely an option. And if there's no, I'm seeing some nodding heads, so I will proceed to that option. And so I will read this out, and then we will, unless there's opposition, we'll assume that they're passed on division. Shall vote 1 under the Office of Commissioner of Lobbying, vote 1 under the Office of the Conflict of Interest and Ethics Commissioner, vote 1 and 5 under the offices of the Information and Privacy Commissioner of Canada, and vote 1 under the Office of the Senate Ethics Officer, less the amounts granted on interim supply carry. Seeing no opposition to that, that is passed on division. Thank you, colleagues. That was painless. We'll move now to committee business. Mr. Angus, you did indicate that you did want to.
Mr. Chair.
Pardon me, Madam Clerk.
Would the committee like to have it reported to the House?
Pardon me. That is, that's an important one. Is there, shall I report these to the House? Getting heads nodding, that is passed. Thank you, Madam Clerk. Moving to committee business, Mr. Angus, you indicated that you'd like to speak to committee business, and then if anybody would like to follow, please raise your hand and we'll go through the speaking order as indicated. Mr. Angus, we'll turn to you.
Thank you, Mr. Chair. I'm speaking to my motion today to invite Mr. Stéphane Guilbeault, the Minister of Heritage, to come to the Ethics Privacy Committee to testify on the plans that are being led through the Heritage Department to deal with the allegations of non-consensual sexual assault videos that exist on Pornhub. We were informed by Security Minister Bill Blair at the April 12th ethics meeting that the government of Mr. Trudeau will, quote, introduce legislation to create a new regulator that will ensure online platforms remove harmful content, including depictions of child sexual exploitation and intimate images that are shared without consent. That public safety and other departments are working on this proposed legislation with Canadian Heritage, which leads this effort. But we have had no indication of what this new regulator is, and I think we need clarity. I would just step back a minute and say this all stems from the December 2020 reports that came out of the United States on horrific abuse of children and sexual assault victims on Pornhub, a company that is based in Canada. We began our study at that time to see if our laws were insufficient, if there was a problem. We asked the RCMP to come. The RCMP have made it clear that they are not moving forward with allegations against Pornhub. They've talked about them being a partner. They've talked about voluntary compliance. We were given, well, I received the RCMP's internal briefing documents in response to the December 2020 article. And in that document, it talks about what next steps have to be done, and it mentions the leadership of the Heritage Department. We asked, my office asked the RCMP to send us the blacked out information to explain why the RCMP is deferring to Mr. Guilbeault's office. We were told, my staff was told, that this would breach cabinet confidence. So what that tells me is that after the December 2020 article came out in the New York Times on Pornhub, this issue was discussed at the cabinet of Prime Minister Justin Trudeau. And a decision was made then to have Mr. Stephane Guilbeault and the Heritage Department handle this file rather than transferring it over to police or the Attorney General or to public security. And I think this is really important. We cannot finish our Pornhub study without knowing what exactly is the government's plan, because we have Bill C-10 right now that Mr. Guilbeault is in charge of. And under C-10, the government, I think, shocked everybody when they decided to put user-generated content under C-10. I've talked to many arts organizations who are shocked that Bill C-10 includes user-generated content. It is nothing that the artists community have wanted. They want Facebook and Google to pay their share. So where is this user-generated content coming from? Is this to address the allegations that the survivors brought to us on Pornhub? If that is the case, then Mr. Guilbeault needs to explain that, because I don't think you could disrespect survivors in any more of an egregious fashion than to suggest that sexual assault videos of torture of children that was brought forward to our committee is somehow considered user-generated content in Canada. What does that say to survivors? What does that say to the women of the Global South that I have been meeting with who are speaking from Nigeria, Colombia, Spain, France, talking about the sexual assault videos that from their countries that are being posted on a Canadian site? So are the Liberals telling us that they consider sexual assault and criminal acts mere content that can be handled by a regulator? Are they going to handle it off to the CRTC under Bill C-10, or are they going to create a new pornography regulator? I would like to know what that pornography regulator would be, because, again, I had excellent meetings following the debacle of our meetings with the sex workers, and Ms. Lukings provided really interesting analysis of how what we want to do is make sure we hold corporations accountable for what's online, but we don't want to push stuff to the dark net. So if the Liberals have this idea that Mr. Guilbeault could set up some kind of regulator to tell us, I don't know, Canadian content in porn, good porn, bad porn, do we need a regulator, or do we simply need the Liberal government to apply the laws? Because if you look at the laws that we have in Canada, Criminal Code Section 162, that it is a crime to film the private acts of individuals or people without their consent. It is a crime to circulate, to sell, to advertise, or make available the recording. We have a law. Section 163, that sexual videos of crime, cruelty, and violence are classified as criminal in behavior. What we heard from the survivors of non-consensual sexual assault video is that their videos are videos of crime, cruelty, and violence. We have Section 164 that gives the authorities, that would be the RCMP, the power to issue warrants to seize the recordings of voyeuristic videos of crimes, as well as child pornography. We have the mandatory reporting laws, which we have learned that Pornhub has not followed through on. Pornhub has not respected the laws that we have in this country. The Attorney General doesn't seem to even think it applies because he's not sure if this Montreal-based company is a Canadian company. So if the Attorney General, who lives in Montreal, isn't sure that Pornhub is a Canadian company, even though their address is on Descaries Boulevard and everyone in Montreal who goes to work passes their office in the morning. If he's not sure they're a Canadian company, how are we expected to believe that the CRTC or some kind of regulator is going to handle this? So I think Mr. Guilbeault needs to come and explain to us what is the government's plan for dealing with issues of sexual violence that have come to our committee on Pornhub. Are we going to ignore Canadian law? Or are we going to establish the CRTC to do this? Is this going to be Bill C-10? Or, as Mr. Blair suggested, they're going to create a new regulator. I think Mr. Guilbeault needs to come and inform us so we can actually finish a report on what Parliament needs to do to address these disturbing allegations of brutality and non-consensual sexual assault of women from not just Canada, but around the world. We need to be able to respond to those survivors and to the Canadian people that we've done our job, and we cannot do that job without Mr. Guilbeault coming and explaining why he is the lead person appointed by the Trudeau government to address these very, very serious allegations. So I'd like to bring forward that motion for a vote.
Thank you, Mr. Angus. On the debate on the motion, I do have, see hands have been raised, and so we'll go to Mr. Baird first. Mr. Baird.
Yeah, thanks, Chair. Thank Mr. Angus for bringing the motion forward. Obviously, it's in line with the study that the committee has undertaken, and could serve to be one of the final meetings potentially we have on that as the calendar quickly. We start running out of days, but I in fact was seeking the floor, and would just ask now that following consideration of Mr. Angus's motion and the committee voting on it before we adjourn, if we can get an update from you, Chair, on the work that the committee is to undertake. You mentioned this at the start of the 2 hours, so I don't want to hijack the time. We do have a motion on the floor to consider, and look forward to the discussion on that. I plan to support it, but I just would ask that before we do adjourn, if that is to happen hastily, that we get an update on the size of the draft report that we're reviewing next week, and our plans to report that to the House 10 days from today, per the committee's previous direction. Thanks very much.
Yeah, thank you. As I indicated earlier, the next two meetings, the meetings next week, have been set aside for the consideration of the draft report on the questions of conflict of interest and lobbying in relation to the pandemic spending. My understanding is that report now exceeds 150 pages, and so it will be robust. And I'm sure that we're going to require at least those two meetings in order to review that. And of course, we do have a deadline that has been agreed to by this committee to have that completed next week. And so that is the case. But we will continue now the debate on Mr. Angus's motion. We have Madame Goudreau. Madame Goudreau, we'll turn to you.
Oui, ben je vais garder mon...
Yes, I did have something else to say, but as to the motion, clearly when you realize we have 7 meetings left, from what I gather, Mr. Chairman, we would have 4 on reports. So really only have 3 meetings. So my question is this. Okay, well, there was a motion that may be tabled today. I'm trying to understand, on behalf of the people that are following our work, watching us, if we get back to the motion, the basic motion, which was to meet, I think it was in December, right, to meet the owners and executives of Pornhub. Of course, if we open things up here, we're going to want to go further. And the issue is we're unfortunately not meeting 20 hours a day, a week, or 5 days a week. And I'm really concerned here. My concern is that we should finalize our reports because, frankly, it might take longer than we expect, and we know that we've gone beyond. So that is a concern for me. If we have 3 meetings left, I'm convinced others among you also have suggestions to finalize, to end the session as we had begun it. I won't say any more on that. I am really concerned about this issue of effectiveness. I mean, on behalf of the people that are watching us and trusting us, taking into account the limits of what a committee can do. When a committee studies an issue in depth, same thing with Pornhub. We've already said there is a different angle taken by the committee, the Status of Women Committee, and then the committee is now analyzing C10. I just want to make sure we're doing a good job in the right circumstances, in the right area. First thing I'd like to say. Thank you.
Thank you, Mr. Fergus. We'll turn to you, Mr. Fergus.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chairman. I would like to support Madame Gaudreau. I am very much in favor of what Mr. Angus proposed. I think it's important for us to examine this issue. I'm really pleased that Mr. Angus also expressly mentioned Madame Bookings, the dark web, and the importance of having a discussion. We are all aware of the fact we don't have much time left before the end of the session. So there's probably some way for us to manage all of these requests in an effective way. I think, personally, if there is a way to perhaps combine Mr. Angus's motion with Ms. Shanahan's motion, tabled a few weeks ago. I think if we do that effectively, we can complete our work and give ourselves time to consider the report that we're currently working on and do good work. That's what I wanted to point out to my colleagues on the committee.
Thank you, Mr. Fergus. We'll turn to Mr. Dong. Mr. Dong.
Thank you very much, Chair. I listened carefully to my colleagues' previous arguments and their position with regard to this motion. What caught my attention was the fact that Mr. Angus mentioned that he received briefings on the dark web and from Ms. Lukens. That reminded me that was the part that I had a lot of interest in, and I think my fellow colleagues also asked questions about those, but we never really had a sort of a fulsome discussion or session to hear a bit more information about the dark web. And I think, to be fair, the last meeting that we had when we had these witnesses from the advocates of sex workers, they didn't get a fair chance to express, to maximize their time at the committee to express their full perception on this study. So I think it'll be very good, and I spoke previously in support of Ms. Shanahan's motion to invite them back, and that adds to the comprehensiveness of this report. As to Mr. Angus' motion, I understand where he's coming from. Although it does based on a lot of assumptions, and there's assumption that the government is moving to legislate, to regulate this industry. But I think, I'll go with the decision of the members of this committee, and I would support it if we can, consider a friendly amendment, which I want to, move for members to consider, that following the word in the original motion, Brenda Lucky, I would add that the committee hear from experts on the dark web for 1 hour, and that the committee invites Ms. Lukens to be part of that panel. So I'm moving a friendly amendment.
Point of order?
No, recognize a point of order, Mr. Angus.
Yeah, because it's because we're jumping around a bunch of different stuff here, so I just want to be clear. So Mr. Dong's saying that we will have Mr. Guilbeault and have Ms. Lukens give us her presentation on the dark web.
Well, exactly what my amendment says.
Perfect.
Okay. Debate on the amendment. Is there anybody that would like to speak to the amendment? Okay, there's seeing hands raised. Ms. Shanahan, you are next in the list anyway, so we'll turn to you. Then we'll go back to Mr. Angus.
Point of order, Chair.
Recognize a point of order, Mr. Baird.
Yeah, can we get the motion, the complete text of the motion with the with the amendment circulated in both official languages, please?
Yes, I'm getting hand gestures that indicate that you're not the only one that was looking for that. So we'll now suspend until such time.
They were friendly hand gestures. I would just note, Chair, for those following along.
Let's just remember that there's no such thing as a friendly amendment in this business. It's all just an amendment or not an amendment. And so while we are friendly and sometimes we accept them more readily in this business in Parliament of Canada, there is only amendments. We will suspend now until such time as that can be distributed in both official languages. Please watch your email for those to be distributed. next intervention.
Well, thank you very much, Chair. Thank you. Just to note that I too had a motion that I wanted to present, and I understand that'll occur after this is dealt with. But it is concerning the order of the House regarding the nomination of the extension of the term of the Privacy Commissioner. But on this amendment, yes, of course, I'm in agreement because it follows on what I was attempting to do, not very elegantly. I agree. When we had our last panel of witnesses on this issue, that we are becoming aware that there is what is seen and there is what is unseen. And it is not for nothing that our study on MindGeek and Pornhub has really stirred up so much attention amongst ordinary Canadians and the media. It's because we are, I think, for the first time in as this is a completely new area of study, the internet space and the web, the dark web, things that I certainly didn't have any knowledge of prior to really recent revelations that we've had over the past few years about just who and what, as far as we know, operates in this space, but we don't know. And so since that study, it's so critical. It's about the non-consensual use of images. We need to get a fuller understanding. I think this is really one of the first times that a parliamentary committee is attacking this area. I certainly am, that is what I was trying to do when I moved my motion during that meeting a month or so ago, that we should hear from more witnesses. I'd like to hear from Professor Lukings again. She certainly had a lot to say on this issue, and also we may be able to find someone else, perhaps the RCMP or a retired RCMP officer who's worked in this area, who can maybe speak, much more freely about this, about the kind of work that he or she has been seeing. I really think that this is an area that we need to more fully explore, because we need to have as much information as possible before we're ready to do that report and put forward recommendations that I think will be very welcome, by the Canadian public. I'm not saying it'll be the last word on it, far from it, but I think it's going to be a very important step forward in opening a crack in this door, which clearly has been closed, because, of course, our intent was never in addressing the issue of Pornhub to drive the illegal traffic to the dark web. That was never our intention. So we need to understand what we are doing in this space, and for that reason, I support the amendment. Thank you.
Thank you. Just to remind committee members, I think there may be some confusion, but Ms. Luking is not a professor. She is a law student. Just for added clarification. We'll turn to Madame Goudreau. Pardon me, Mr. Angus was on the list next. I apologize, Mr. Angus first.
Thank you. I think we can work this out. I do have to say, from that last meeting, I felt very, very uncomfortable with this committee, because we said we were going to make a safe space for survivors, and that didn't happen. I also felt that we have to really be careful about what it is and how we're talking about it, because the survivors that came to us, we said that we would hear their stories with respect, and that did not happen. And I also say some of those witnesses to me were gaslighting the survivors that we had heard from. I mean, we heard some really horrific testimony. So if I am to support Mr. Dong's amendment, I think Ms. Lukings, I've spoken with her. I think she's really, really articulate on this and would be very helpful. And I think that, but his motion is about the dark web. So if the witnesses that we're going to agree on are experts in the dark web, I'm open to that. And then I think we're going to have to close off this study because time is ticking on this Parliament. If members want to use that as a way of bringing other witnesses who have other points of view, I've been on the phones with women dealing with Pornhub from Spain, Italy, Colombia, Eastern Europe, Nigeria. They would love to speak to this committee. So if we're going to open it up, then I say really open it up. Or we're going to actually get this thing finalized. I think Mr. Guilbeault is important because we were told by Mr. Blair that the government is introducing legislation and that Canadian Heritage is the lead, so we need to hear from them. I'd say if we heard from Mr. Guilbeault for an hour, we heard from experts from the on the dark net, including Ms. Lukings, and maybe, as Madame Shanahan said, a retired or someone from the RCMP who deals with this, or some expert, Project P perhaps, then I think we're in a situation where we can finalize this report. So if that's the agreement, I'm ready to put it to a vote at any time, because I know Ms. Shanahan has another motion that we've got to vote, and time is ticking, so I'm ready to vote now if that's the agreement.
Yeah. I've got a couple of people left on the speaking list, Madame Gaudreau, Mr. Baird, and then I think Ms. Shanahan got back on the list here. So Madame Gaudreau.
Oui, donc je continue.
Yes, so to continue in the vein of what I was saying earlier on, of course, we need to be concerned about this issue. I think you saw how I reacted at the end of our committee. I was even ashamed of it. How do we close off what we've discovered at the time when we began shedding the light on Pornhub? There is one concern that I have, and that's why I'm very comfortable making changes here. I understand fully well that with respect to Pornhub, we really could study the issue for much longer. There is a report that takes us at least 2 meetings on the issue of conflict of interest and lobbying. I'm already reflecting on or thinking about the timeline. So what's missing for us to be able to really shed light on this and get to the bottom of this with this motion and the sub-amendment is the time factor over time. So to my mind, I'm asking myself whether we should have the meeting and then still wait till the end of the report, or have all reports and then open up a window to finalize the report. And that's why I'm very uncomfortable at this point with voting. I would vote if there was an amendment and it was understood that the work or the issues covered in our 2 reports, that we don't have that come in first place, that we finish that work, have it accomplished, and then I'd be fully comfortable with continuing on with what we weren't expecting or hadn't provided for at the very beginning, but which we're all conscious of needs to be dealt with. So I'd like to hear this. I'm not officially tabling it, Mr. Chairman, but of course, before we talk about Pornhub, the report on the work that's been done on the conflict of interest and lobbying, that's a priority. Now, I need to hear more arguments because perhaps I don't have enough experience, but I think the report that we'll be getting on privacy and the platforms, this whole Pornhub web and then the dark web, then it talks about, then we're dealing with heritage and it affects a number of other committees. So we need to finalize things. If you're telling me that it's really important that we have that one meeting and that the analysts will be in a position to provide the final version of the report so we can take a look at it, I have no problem with that. Otherwise, I would bring an amendment. So we will address everything once the study of reports is complete. Thank you.
Thank you, Mr. Barrett.
Yep, thanks, Chair. I agree with Ms. Gaudreau's sentiment, and I'm just curious if there is an interest from the mover of the main motion or the amendment that that we include language that would conclude the study, that this would conclude the study, and that the committee then provide instructions on drafting to the analysts. And so I'm a little reluctant to move the amendment. I appreciate that's how we make a decision on it. I'm a little reluctant to move it because my intention is to not prolong this discussion. I'm comfortable with the proposed hour from Mr. Angus, the proposed hour in the amendment. That all makes sense, but my concern is that time is a premium. The 2 meetings next week are committed. There's been a mention of a proposal from Ms. Shanahan that I can't speak to until it's been tabled at the committee. And so I do see some agreement there. And so I'm not sure the best way to do that, Chair. If it would be if the preference of the Chair is that I do move the amendment, or perhaps I'll defer to the mover of the main motion, and I'll just cede my time. I'll cede my time there. My intention is that we include language on concluding the study and providing instructions on drafting to the analysts following the conclusion of that 2-hour meeting.
Thank you, Mr. Angus. Next, but just before that, I do want to inform members that the analysts have begun the work of putting together much of the report. Obviously, we will have to confirm drafting instructions, but they have been diligent in terms of preparing those things that they are able to up until this point. And so, but we do have to be mindful that they still will require time to complete the work. And if we add additional witnesses, we will make it more difficult to get that completed before the end of this sitting. Mr. Angus.
Thank you. Well, time is absolutely important because we have responsibilities. We have agreed to the meetings to finish the pandemic report and to have it reported back to Parliament, I think, by June 10th, I think. So that's there. I think my colleagues from the Liberals would have brought forward, it's very reasonable. It allows us to at least say that we've touched all the key areas. There are many other areas, but obviously time's run out. So this would allow us to finish that. I would trust my colleagues that we've agreed that these would be the final meetings and we move on. And that we would all agree to that. We could put it in as a motion and an amendment and vote on it, or we can just say we all recognize time's ticking. We got to get this done. We get that meeting. I'd say we vote on it now because Ms. Shanahan also has a motion, and we probably want to hear that one. So if we could just vote on this, I think we can agree that this will be the final meeting on this study. We'll wrap it up, and I think we will have done a good opening round of work for the Canadian people, and it has raised a lot of questions, and we can't answer them all, but this is a good way that we've opened up a study that people can look at, and maybe in a future Parliament or down the road, someone else will take from where we've started, but we need to finish it off. So I don't know that we need Mr. Barrett to put it in writing. I think we just agree that this will be the end, and we move on from here.
Okay, I see Madame Gaudreau, but just to remind members, we have to vote first on the amendment and then on the main motion. But Madame Gaudreau,
Donc, moi, je propose que.
I propose the following, that we add, as Mr. Angus was saying, that we'll address the work on the reports on the conflict of interest issues, that we then followed by that last little bit so we can complete the report on the reputation of those platforms like Pornhub, etc. That should be set out in time so that we can be sure that the next 2 meetings will really be dedicated to our first report. It has to be written somewhere because there could be filibustering, anything. So we need to have some agreement in writing.
Mr. Angus, we'll turn to you.
Sorry, my understanding is we already have an agreement. We voted that we were going to have this report done and reported to Parliament by a date, and so it's already there. So I think that is what we do next. We understand that we have to finish the pandemic report, and it will be reported to Parliament by the date. So I say we get to the vote on this motion now.
Okay, we'll move to a vote on the amendment. Madam Clerk, I'm wondering if you'll run through the roll call for the purposes of the vote on the amendment. This is Mr. Dong's amendment, and then we'll vote on the main motion.
Okay, so on the amendment of Mr. Dong, those in favor, please say yay when your name is called. Those opposed, please say nay. Mr. Dong.
Yes.
Mr. Fergus.
Oui.
Ms. Latanzio. Ms. Latanzio.
Sorry about that. Yes.
Ms. Shanahan.
Oui.
Mr. Sorbera.
Oh, you can call me Francesco. Oui.
Mr. Barrett.
Yay.
Dr. Carey.
Yes.
Monsieur Gould.
Oui.
Madame Gaudreau.
Oui.
Mr. Angus.
Yes.
10 for, 10 pour, and 0 against.
Thank you, Madam Clerk. That passes. Now, members will vote on the amended motion. So the motion as amended. Madam Clerk, I'm wondering if you'll run through the roll call again.
Thank you. Mr. Dong.
Yes.
Mr. Fergus.
Oui.
Ms. Latanzio.
Yes.
Ms. Shanahan.
Yes.
Mr. Sorbera.
Yes.
Mr. Barrett.
Yay.
Mr. Carey.
Oui.
Monsieur Gould.
Oui.
Madame Gaudreau. Oui. Mr. Angus.
Well, oui.
Yeas pour 10, nays contre 0.
Okay, thank you, Madam Clerk. That's and members, that's very helpful. I'm glad that we can do that. Of course, next week our meetings are scheduled to be the review of the report on pandemic spending. But I think Ms. Shanahan may have some suggestions for meetings in the week that follows. Ms. Shanahan.
Well, thank you, Chair. And I believe that the notice of motion has already been circulated. But yes, I would like to move that pursuant to the order of reference of Thursday, May 27, 2021, and to Standing Order 111.1, bracket 1, Danielle Terrien, nominee for the position of Privacy Commissioner of Canada, be invited to appear on Friday, June 4th, 2021, for 1 hour in relation to his proposed appointment. And so I believe that has been circulated already in both languages.
Okay, we'll turn to
Chair, if I may, just one little point. Just on the date, I just chose the closest date handy, but I'm open to an amendment if there needs to be a change of date with the scheduling of witnesses that we have already discussed.
It appears as though there's a conflict. Maybe we can resolve this. Mr. Angus, we'll turn to you first, then we'll go to Mr. Barrett to follow.
Thank you. This is the work of our committee, so I think it should be pretty much unanimous that we support this. My only question is that Friday is a day that's already been allotted, as Madame Gaudreau had said in the WE study, or the pandemic study. So I think we should have it at an early date after that. But I think, being that we don't want to go much over time because of the work, the pressure it puts on our interpreters, that I'm ready to fully support it, and let's just find a date and make it happen.
Mr. Barrett.
Thanks very much, Chair. So I think that having the Privacy Commissioner nominee appear is good. I'd also I have an amendment that I would like to move. I'd like the minister to appear for a second hour. So I will send this in both official languages to the clerk as soon as I've read it. The motion as amended would read that pursuant to the order of reference of Thursday, May 27, 2021, and to Standing Order 111.1 Sub 1, Daniel Terrier, nominee for the position of Privacy Commissioner of Canada, and Minister of Canadian Heritage, Stephen Guilbeault, be invited to appear on Friday, June 11th, 2021, for 1 hour in relation to Mr. Terrier's proposed appointment. And I am sending that to the clerk right now.
Okay, colleagues, as is our custom, we will suspend until such time as that can be distributed to members in both official languages. So we'll suspend. Meeting suspended. Should officially call it back to order. Madame Gaudreau, we'll turn to you.
Oui, merci.
Thank you, Mr. Chairman. Just to make sure we're on the same page, can you explain the sequence of events for what's left, given that date of June 10th, and then on the 4th we won't have finished, given that we have an extra 2 hours for Pornhub. So we still have time until June 21st. Would it be possible to give us a breakdown of the available openings? And my second question is this. I'd like to know a little bit more about Mr. Barrett's reasons for wanting to invite Minister Guilbeault for that appearance. Those are my two questions. So a plan and why Mr. Guilbeault.
Okay, I think, Madame Gaudreau, you have indicated that your calculation of days is that we only had 3 days that were freed up. I think I am in concurrent. I agree with you that we are very, very limited. And so I'd be interested in members' thoughts on how we can make this all happen. But we'll turn to other members here. We'll turn to Mr. Fergus.
Merci, Monsieur le Président.
Thank you, Mr. Yes. Madame Gaudreau is far more diplomatic than I will be. We've just noticed eloquently that we don't have much time left. And we'll be having the minister who will appear under Mr. Angus's motion. I'm not sure how we can invent time, really, given the limited time we have left to complete the studies that we've already begun. I think there was a good consensus amongst all of us beforehand that we were just going to, that we would set a limit to the other debate because there was no time. So I think that it's not necessary to go there given what we have ahead of us, but I'm awaiting Mr. Barrett's answer as to Madame Goudreau's questions with great interest.
We'll turn to Mr. Angus and then Mr. Barrett.
Thank you. I appreciate my colleague's amendment. I guess my concern, like Madame Goudreau, is the clock is ticking, and we're having the minister come to speak to us. To have him come back on another issue, to me, is questionable. We could actually question him on both things if people feel that that's what they want to do. But I think we have to get Mr. Thérien's appointment approved. I think that that's incumbent upon us. We have to finish the pandemic study. We have to finish the Pornhub study. So I would say that having him come back for another hour is not necessary.
Mr. Barrett.
Well, I would just say that in the interest of saving the committee time, I'd be happy with the unanimous consent of the committee to withdraw the amendment if Madame Shanahan withdraws having Mr. Therrien here. Mr. Guilbeault is the minister who's proposed this individual for the appointment, and so if we want to save a full day on the calendar, let's do it. But if we're having a meeting, if someone has a proposal how we're going to split time for that 1 hour, let's hear that proposal. But if we're dedicating a meeting, I don't think that it's unreasonable to ask that the minister who is proposing the appointee. We just had Mr. Therrien at the committee, and no one had any questions or said that they had further questions about Mr. Therrien's service. So I would be happy with the UC of committee to withdraw my amendment, and we could withdraw having Mr. Therrien appear, and we can deal with Pornhub on that day and drafting instructions and the like. But if we were blocking meetings, if we're doing some planning, that's the proposal that I'm making. So Mr. Guilbeault is the minister that put Mr. Therrien forward, but like we're going to have Minister Guilbeault appear on another matter, we just had Mr. Therrien appear. So with such little time left, I would concede that we could do without both.
Madame Goudreau.
J'ai plein d'idées.
I have tons of ideas. How to maximize our time? Well, we've seen it. We saw it with Mr. Dion. We basically had our questions answered quickly. We continued along on another more specific question relating to the most recent report. We had 1 hour. So I have a question, Mr. Chairman. Is it necessary to plan for an hour if we can't sort of add time for Mr. Guilbeault? Of course, there will be, it's up to members what they want to ask in terms of questions, as was the case with the commissioner, and then also to shorten that because we won't have much time. In June 4th, I don't think it's possible, but it could be set out that on the June 24th at the latest. So we'll continue our work. There'll be the report. There'll be the last day on Pornhub. There'll be the report. There will be that little bit left based on our colleagues' proposal. The date that she's proposing just doesn't work with what we've proposed. But I think we could simply add the time, which is less than an hour. Maybe 30 minutes is enough. And by June 21st, we could be sure that happens. But we have to face reality.
There's definitely a possibility to add time to meetings. We have often gone beyond the 2 hour time limit. But as Mr. Barrett has suggested, if we're going to set aside 1 hour of one meeting, the second hour would have to be dedicated to something. So it could be to the minister if in fact we are doing that. And again, I would suggest that we push this off until such time as we've been able to deal with some of the heavy lifting on some of these other reports, so that final translation will be allowed to take place before the House rises. Mr. Barrett, you're the last person that has indicated that you want to speak to this. And of course, we are still debating the amendment. Mr. Barrett.
Chair, I just being mindful of the time. It's 3:15. I am certainly not opposed to hearing from Mr. Terrier. I do think that it would be helpful to hear from the minister. I think we could. There's a couple different ways that we could look at this. This is perhaps a discussion that we could resolve offline. I would suggest perhaps that we adjourn debate and then we have meetings planned next week, and we can perhaps the chair could come back to the committee on Monday with a proposed work plan for the remainder of this sitting, and we could do that. So you know what, Chair, with that said, and again, just underscoring that I am, I think there people are interested in hearing from Mr. Terrier. The way that we do that and the time, being sensitive of folks' time, I'm going to reach out to colleagues and see if we can resolve this offline. But at this point, I'd move to adjourn the meeting.
Okay, there's been an amendment. There's been a motion to adjourn the meeting. This is not a debatable motion, so we'll move to the clerk. Ask the clerk to run through the roll call.
Thank you, Mr. Chair. On the motion that the meeting be now adjourned, Mr. Dong?
No.
Monsieur Fergus?
Non, Madame la greffière, je m'excuse.
Madame Latencio?
No.
Ms. Shanahan?
No.
Mr. Sorbera?
Nope.
Mr. Barrett?
Yay.
Dr. Carey?
Yes.
Monsieur Gould?
Oui.
Madame Gaudreau?
Oui.
Mr. Angus?
Oui.
Yeas pool 5, nays compte 5.
I will vote in favor of the adjournment, and so I will now move to adjourn this meeting. Meeting adjourned.